Welcome to this session, Legal Roundtable, Advancing Climate Justice, Reimagining Accountability, Climate Displacement, and Equitable Loss and Damage Responses, hosted by Loss and Damage Youth Coalition, School of Oriental and African Studies, or SOAS, University of London, and Global Choices during the 2025 UNFCCC COP30 Climate Law and Governance Day. Thank you for joining us. I will hand over the floor to Professor Pushpa Kumar Lakshmanan, Professor of Environmental Law at University of Delhi and former faculty associate at Harvard University, and also Dr. Ramesh Ralia, Chief Scientist Officer of Tidal Grow Agri-Science in Washington, USA.
Thank you very much. Thank you very much. And very good afternoon and good evening to all the speakers and discussants and the moderators, rapporteurs, all the participants who are here for the session. Here we are in a very important session on advancing climate justice, reimagining accountability, climate displacement, and equitable loss and damage responses. In this, we are going to explore several important questions. One is, how can the international legal system overcome the widespread immunity for environmental crimes by ensuring justice and compensation for the victims? This is one of the major challenges that we face today in this world. You all know that what kind of, the crisis that we have in dealing with environment, and how in different jurisdictions people are getting affected. Health is affected, their productivity is affected, their life is affected, and enormous damage to environment is happening, particularly in the context of a climate change. Lot of loss and damage is being visualized, and people are suffering. Lots of sufferings going on in different countries. There are many reasons for that. Legal and policy instruments have to work well, and the states have to come out with different strategies to combat climate related actions. There are many countries that are taking proactive actions, but still these are all not up to the mark. So every country is having different kinds of situations. In this context, there are, at the international level, there are several efforts being taken. One of the major efforts being taken is under the Paris Agreement. Under Article 8, there is already negotiations going on. Efforts are being taken to assess and to come out with the solutions for loss and damage. But many countries are not really coming forward to do their due work in this regard. But positive signs are coming up. Most of the countries recognizing right to environment as a fundamental right in different jurisdictions. That is one thing. And the Inter-American Court of Human Rights coming out with the advisory opinion, recognizing the right to environment and the right to stable climate as one of the important rights and pronouncing it as a jus cogens. And the recent ICJ Advisory Opinion on the obligation of the states in respect of climate change. These are very welcome steps. How we are going to implement them, how we are going to operationalize in the international context, that is one major challenge that we need to, as experts, as the people working in this area, how we look at it, and what are the strategies we can propose in implementing these aspirations. Number two, I would like to ask all the panelists here, the discussants as well as the speakers, to think about, when we are talking about the international responsibility and responsibility between the states about for the harm happening relating to climate change, what is the responsibility of the states themselves? That also we need to look at it. Whenever we are looking at, at the international level, when we create the legal principles and the legal commitments for the states, how the states operate within the jurisdictions. Ultimately, that is going to really consolidate our strength, provide solutions all over the world. Most of the times, the state within the jurisdictions, they don't function. One of the classic example is the Bhopal gas tragedy. All kinds of legal instruments were there. They also got the permits, everything from the state. But the big, damage happened. The gas leak case, methyl isocyanate. And what is the responsibility of the state machinery there? That also we need to look at. So when we look at in the ICJ level, so when we are looking at the international remedies, what is the remedy that the individuals, the people have within the jurisdictions against the states? That also we should to look at. Then we need to also think about what kind of a solutions the people can make. At the international level, there are climate-induced migration happening, displacements happening, and this provides all kinds of miseries to people. What kind of remedies we will give, what kind of solutions, and any kind of the damages we need to give it to them. How people's rights can be protected in this context. So these are the verticals that we need to look at when we are analyzing different topics. I would like to invite now Dr. Ramesh to provide his views. Then we'll go to the speakers one by one. Dr. Ramesh, please take over.
Sure. Thank you, Professor Pushpa Kumar. Really appreciate your insight and highlights on overall about the session. Respected excellencies, distinguished delegates and colleagues and speaker, good afternoon, good evening to everyone. It is my honor to welcome you all to this legal roundtable on advancing climate justice. As climate impacts intensifies through rising seas or extreme temperature, weather, and irreversible environmental harm, communities around the world are experiencing losses that they did little to cause. Yet accountability for this harm remain uneven, and many affected people still lack access to justice, protection, and meaningful remedies. Today's discussion in this roundtable session is important as we consider how the international legal system can help close this gap, and the ongoing processes towards an ICJ advisory opinion that offers a valuable moment for reflection on states' responsibility and how international law can support fair and effective response, as Dr. Pushpa Kumar was laying out with an example of Bhopal case tragedy. And this including operationalization and the losses or damage related funds. We also faces the growing challenges of climate-induced displacement. As earlier, Dr. Professor Kumar mentioned, migration. Millions are being uprooted, often without clear legal protections. And as we look ahead, the international communities will need to consider how legal framework can better address cross-border displacement because of climate change impacts and safeguard their rights and support their cultural and non-economic losses that many communities endure. I look forward to hearing insights from all the speakers and audience here through their questions and feedback on how we can strengthen the accountability, ensure justice for those most affected, and help shape a legal system that responds to the realities of rapidly changing climate. With that, I would like to thank you all the speakers, all the participants, and would love to hear what are the insights in this session.
Thank you. Thank you very much, Dr. Ramesh. Now we'll go with the speakers.
Thank you so much. I hope you can hear me properly. Professor Kumar and Dr. Ralija, it's such a pleasure to have you as such eminent chairs, and thank you for your insights. I will start speaking about reimagining environmental accountability. I'm Raquel Clavijo, human rights and environmental lawyer, and I will be speaking alongside my colleague, Harendra Beniwal, PhD scholar and tutor at SOAS University of London from India. We are going to focus on ways to improve environmental accountability. The photo that you can see here is on the Niger Delta, which has suffered from oil spills by different multinational corporations since the 50s, with long-term consequences for the health and livelihood of the communities of the Delta. Environmental destruction has reached a comparable scale to armed conflict, yet international law continues to treat it as a peripheral concern. Each day, 1.09 million tons of pollutants are dumped into our seas and rivers. One, not only wildlife, but entire ecosystems. There is a widespread and alarming lack of accountability for environmental crimes. Corporate accountability, particularly in voluntary arrangements and so. Moreover, the absence of an environmental court leaves transborder crimes without a dedicated adjudicatory forum. The so-called ecocide is observed mostly in the global south, and existing solutions remain underdeveloped. Who is committing environmental crimes? Among the perpetrators, we have multinational corporations, government actors and officials acting in situations of armed conflict, individuals and criminal networks, among others. Regarding the victims, recent research reveals that the global north is responsible for the 92% of the global climate breakdown, while the victims are disproportionately located in the global south. Additionally, environmental degradation disproportionately affects women and girls and their ability to perform their everyday tasks. Last but not least, indigenous communities are particularly affected as their lives are tied intrinsically to the natural world. What has been proposed so far? Currently, as I mentioned previously, the International Court for the Environment does not exist. There is no adjudicatory forum for judging environmental crimes. Different academics and associations have proposed its creation. Other proposal that has been put on the table was the one made by scholar Richard Falk, who was amongst the first to call for the criminalization of ecocide. He drafted actually an ecocide convention that never entered into force. On the other side, the International Court of Justice established a chamber for environmental matters from 1993 until 2006. However, no state in this range of time ever requested a case to be brought before the chamber. However, there is light at the end of the tunnel, as growing momentum has driven the movement towards the recognition of a new crime, the ecocide. This raises the question of whether the codification of ecocide within international criminal law represents the missing piece in establishing a just system for victims of environmental crimes. So, criminal law has a unique capacity to prevent harm. It sets moral boundaries, it creates accountability and redirects financial flows. Yet, international criminal law currently remains anthropocentric, prioritizing human welfare while relegating environmental protection to a secondary concern. What we have now, in the Rome Statute, environmental harm is only mentioned once under war crimes in Article 2b4. This is clearly sufficient, as ecocide can happen during peace times and war times, and because of the difficulty of proving the mens rea or mental elements of the crime. A new international regulation of ecocide is necessary. Recent events demonstrate the ongoing destruction of ecosystems worldwide during peace times and war times, from forest loss and river contamination in Ukraine, to agricultural devastation and toxic waste released in Gaza, to deforestation in West Papua and the Grand Chaco, displacing communities and eroding biodiversity. These examples underscore the international legal system's inability to prevent environmental harm and the urgent need for reform. One crucial step in this reform is recognizing ecocide. In this photo, we can see the late UK barrister and ecocide pioneer, Polly Higgins. Polly Higgins founded the Stop Ecocide Foundation, which has led the advocacy movement on the ecocides, and which convened the independent expert panel for the legal definition of ecocide that you can see on the screen now. In June 2021, the definition was proposed as an inclusion of ecocide as a distinct crime in the Rome Statute, in Article 8 ter of it. However, the definition of wanton inserted in the legal definition of ecocide as reckless disregard for damage, which would be clearly excessive in relation to the social and economic benefits anticipated, is highly problematic because of the imposition of a cost-benefit analysis requirement with regards to the excessive damage that may reinforce still the treatment of nature as a resource for commodification. However, on parallel, we have national developments that are signaling an ecosystem of international law, with 11 states recognizing ecocides in their national legal systems, and countries as Ecuador and Bolivia recognizing the rights of nature in their legislation. So we have explored the problem, the origins, and the consequences, as you may imagine, are fatal for the victims. Without legal tools to claim perpetrators accountable and to reclaim redress. The way forward is the recognition of the ecocide as the fifth environmental crime and the establishment of transformative reparations that my colleague Harendra Beniwal will speak about shortly. On good news, as it has been already mentioned on the presentation, two recent landmark advisory opinions have signaled a major win for climate justice. On 3rd of July of this year, in its major advisory opinion 32, the Inter-American Court of Human Rights has recognized the obligation to not cause irreversible damage to the environment and the climate as a jus cogens or absolute norm. This marks the first time any court has reached such a conclusion. The opinion has major consequences, as treaty obligations conflicting with jus cogens norms will have no legal force. The court further clarified that the right to a healthy environment includes the right to an unstable climate. Shortly thereafter, on the 23rd of July, the ICJ issued the historic advisory opinion on the obligations of states in respect of climate change, which establishes binding obligations on states to protect the climate system. The opinion clarifies that states' climate obligations arise from international treaties, such as the Paris Agreement, customary international law, and human rights law. In what refers to the binding obligations of states regarding climate change, this advisory opinion is not legally binding, but it carries significant weight and may be used to argue the inaction of climate change that constitutes a breach of international law. Furthermore, the ICJ has also recognized the adverse effects of climate change, and this can substantially impair the enjoyment of human rights, as the human right to life, right to health, or the right to an adequate standard of living. This overall fundamentally acknowledges that a clean, healthy, and sustainable environment is essential for the realization of many human rights, emphasizing that the protection of the environment is a precondition for the enjoyment of human rights and that both are interconnected. Now, I will pass the floor to my colleague Harendra Beniwal, who will delve into the case studies and talk about transformative reparations for victims. Over to you.
Thank you.
Hello, good afternoon, good evening, everyone.
Yes.
I'll share the slides. Start. Can you see these slides, Chair?
Is it the same slide or you have a different slides?
I have different slides.
Okay. Yeah.
It's coming up.
It's coming.
Okay, can see now.
Yeah. Yep, it's visible.
Is it? Okay, now I can navigate. Yeah, perfect.
Yes, please.
So now I start that we have a framework of ecological justice and the framework of a transformative justice. So when we talk about ecocentric perspective, then there is an inevitable tension between the anthropocentric view, that is a human-centric approach to the environment. So human-centric proposes that there should be economic development concerns should be taken care, there should be poverty elimination. Then ecocentric views takes an ecosystem view, which is a purist approach toward the environment. So this tension is very apparent now in the contemporary world. So what I propose, what we propose, that there need to be a balance between both these approaches, and that is the ecological justice, which emphasizes on the community participation, a community-centered laws, and it should have a bottom-up approach in framing the law, people's participation, and taking ecosystem as a holistic entity, and it should have its own intrinsic rights so that accountability can be entailed. So first I'll discuss the case of a Bhopal gas tragedy. As eminent chair has already mentioned, there was a poisonous gas leak and many people died, around 5,000 people died, and the state stepped into the corporates, because corporates were the foreign entity, and first government tried to bring them before the courts for a criminal trial, but everyone escaped the criminal trial, and then state entered into a compensation deal with the company. And in a compensation claim, commission tribunal, people's participation was very limited, or it was negligible. So the point we can take that there was a lack of environmental accountability laws at that point of time, and state was not prepared to entail the criminal liability. And the after effects of the Bhopal gas tragedy can be felt now on the ground. Still the land is toxic, their environment is completely toxic. So the compensation was meant to be monetary compensation. So now I'll come to the another case study in Niger Delta. In the Niger Delta, there was similar view. There was extraction of oil by the corporates, and no corporate impunity was entailed on them. And there, still we can see that the place is uninhabitable, and there are structural issues that the government was focused on generating the their focus on economic development instead of protecting the environment, protecting the people. So in these cases, in both cases, we can see there were some compensation given, but compensation was just on the surface. So, so we need to dig deep that whether just monetary compensation is enough or environment has its own standing, where ecosystems should be protected with the participation of the people. Like the affected people's, their perspective should be taken into account while framing the accountability policy, and also the measure to help them to rehabilitate. So in this view, so there we are proposing a innovative lens to look into this accountability problem. So we can see from the conceptual perspective, there can be integration of an element of transformative justice and ecological justice. Transformative justice talk about that any compensation, any attempt to help the communities to improve the environment should always be aimed at the structural inequalities, and the we need to inquire why certain problems persist in the society. And so from structural perspective, we need to bring transformations. So this is an innovative lens where the community voice, community participation shall be taken into account. And now this innovative framework we need to apply. So ecological justice talks about that ecosystem, it has its own standing, it has its own value, and it's in congruence with the rights of the nature and earth's jurisprudence. At the same time, transformative justice talk about that the environment should be holistically seen, and the people's participation should be at the center. Those communities who got affected, those indigenous people whose culture, livelihood was dependent on that, and there should be equitable sharing of the benefit. If corporate comes, they need to have a policy in place where the benefit should be shared, and in case of any accident, in case of the spill of the oil in the Niger Delta, and in the Bhopal gas tragedy, a poisonous gas leak, there should be policies and law should be prepared to counter these inexigencies, and then we can remedy it from a comprehensive view, taking people's perspective into account. Now, the global implication is that ecocide, there is a criminal element, like we need to prove the criminal liability, and with integrating the transformative aspect and ecological justice aspect, and we can have an ecocide law in the ICC statute, International Criminal Court Justice, already has given many decisions where transformative justice aspect has been applied. So we can have a broader view to integrate and have come out with an innovative approach to tackle the problems of the environment. With this, I will pass the floor to Global Choices, or the moderator can step in to take the
Thank you very much, Harendra. Very useful insights. Wonderful. Yeah. Moderator, will you be calling the next speaker, or shall I?
Excuse me.
You can do that, Professor Lakshmana.
Yes. Thank you very much. Yes. So now I invite Advocate Muhavani.
Thank you very much, Chair. I would kindly request Harendra to please stop sharing.
Yes, it's being done.
And in the meantime, thank you so much, Raquel and Harendra, for the very succinct arguments on enhanced accountability. I'm sure we all learned a lot.
Thank you, Angelique.
From your presentation. kindly confirm whether you're able to see my screen.
Yes.
Perfect. Just put in presentation mode. Great. So good afternoon, good evening, good morning. My name is Angelique, and alongside my colleague Maeve, in our capacities as affiliate researchers for the Loss and Damage Youth Coalition, we will be presenting on the loss and damage framework within climate change, as well as the ICJ Advisory Opinion and its relevance to this topic area. So to begin with, under the Paris Agreement, there are two pillars of climate action: mitigation and adaptation. Loss and damage involves actions taken to address the impacts caused by the climate crisis that are not or were not avoided through mitigation or adaptation. So loss and damage can be in the form of economic impacts, such as on infrastructure, or non-economic, for instance, on cultural heritage or human and animal or non-human life. So when thinking of the timeline of loss and damage in international environmental law discourse, environmental governance discourse, we begin with the 1992 UNFCCC. At the time of its establishment, there was a large focus on mitigation of climate efforts, but loss and damage didn't really come into the picture until 2010 at COP16, where a work program was established to address loss and damage. In 2013, under COP19, member states finally acknowledged that loss and damage includes and involves more than what is reduced by adaptation. And so they agreed to form the Warsaw International Mechanism, which was created to address this problem through three core functions: enhancing knowledge on risk management, strengthening stakeholder coordination, and providing action and support, either financial, technological, or through capacity building, all under the guidance of its executive committee. In 2015, of course, most prominently, we have the Paris Agreement, under which loss and damage is included in Article 8, and we'll go into that a bit later. And in 2019, at COP25, we had the second review of WIM since 2016, and thus the Santiago Network was born, which is to provide technical assistance for vulnerable countries through the expertise provided by organizations, bodies, and networks and other experts for local, regional, and national interventions. And we also have 2022 at COP27, where the Loss and Damage Fund was established. Now, looking at the Paris Agreement, Article 8 covers loss and damage. Here, the parties recognize the importance of averting, minimizing, and addressing loss and damage associated with the adverse effects of climate change, including extreme weather events and slow onset events. WIM should be subject to the authority and guidance of COP in May, that is the meeting of the parties to the Paris Agreement. And the parties agreed to enhance understanding, action, and support through cooperation and facilitation, including in areas of early warning systems, emergency preparedness, slow onset events, non-economic losses, resilience of communities, livelihoods, and ecosystems. And in fact, a number of these are expert groups within the thematic work streams of WIM. Now, when thinking of the ICJ Advisory Opinion and its relevance, it's important to acknowledge that an advisory opinion issued by the International Court of Justice is non-binding. However, it has authoritative legal, but it's an authoritative legal interpretation provided at the request of an empowered UN body or specialized agency. And thus, advisory opinions generally carry significant normative weight, being that they're from the highest international court. So some of the questions posed to the court under the UNGA Resolution 77-276 on states' obligations to climate change, not some of, but these were the two questions. The first being, what are the obligations of states under international law to ensure the protection of climate systems from human emissions of greenhouse gases and of greenhouse gases for states and for present and future generations. And the second question being, what are the legal consequences under these obligations for the states by their acts and emissions, having caused significant harm either to other states or to peoples and individuals of present and future generations. At this point, I will hand the floor over to my colleague Maeve to take over the rest of the presentation.
Thanks so much, Angelique, for that wonderful presentation. I'll just carry on where Angelique left off, and that's to start off by saying that the ICJ adopted its advisory opinion on the obligations of states in respect of climate change earlier this year in July. It was a unanimous decision, which makes it only the fifth unanimous decision for an advisory opinion in the court's almost 80-year history. So in regards to responding to question A, which was about the obligations of states under international law relating to climate change, the court identified the applicable law that was most directly relevant for answering that question. And so they set out the obligations of states under the climate change treaty framework, so the UNFCCC, the Kyoto Protocol, and the Paris Agreement, but also under customary international law relating to climate change and under other environmental treaties, under the law of the sea and related issues, and under international human rights law. And one of the reasons that that's important is that there were submissions and there were groups that approached the court and asked them to limit their analysis to only the climate change treaty frameworks. But as we know, there's certain countries that are not members or not parties to these climate change frameworks. So by expanding the law that the court looked at, by looking more broadly at customary international law and other aspects of international law, the court was able to rope in those parties as well. So for example, my own country, the United States, which is in the process of once again withdrawing from the Paris Agreement, yet they have the greatest level of historic greenhouse gas emissions in the atmosphere. Now, even if they withdraw from the Paris Agreement, will still be, they will still have their obligations set out in this advisory opinion by the ICJ. So I'll just start off quickly going through some of these obligations that the ICJ set out under these different aspects of international law. And if I have time, I'll go into kind of the legal consequences to what this means. So obligations under the UNFCCC, the court set out that states must take measures to mitigate and adapt to climate change. And so rapid emission reduction and scaled up adaptation finance, as we know, are essential to averting further loss and damage. So this is related. They also set out that Annex 1 states, so developed parties under the UNFCCC, must take the lead in reducing emissions and enhancing carbon sinks. So really trying to enhance that global North countries bear primary responsibility for their historic emissions and that they have to phase out fossil fuels equitably. There was also under the UNFCCC a duty to cooperate that was set out as an obligation. So all parties must cooperate to achieve the convention's objectives. And this, as the court noted, included an obligation by certain developed country parties to provide financial assistance, technical transfers, and other forms of support to developing country parties, especially to those countries that are particularly vulnerable to the adverse effects of climate change, to assist them in meeting their commitments under the UNFCCC. And then under the Kyoto Protocol, although the Paris Agreement has kind of come in and superseded the Kyoto Protocol as the primary kind of climate change instrument, the obligations within the Kyoto Protocol, the court stated, are still in effect. And so developed states under the Kyoto Protocol remain legally bound to their emission reduction commitments that are listed and kind of enumerated within the Kyoto Protocol. So that just reaffirms their obligation to lead mitigation efforts and to avoid further loss and damage in the future. And then under the Paris Agreement, the states have to act in accordance with their common but differentiated responsibilities and their respective capabilities to meet the 1.5 degrees Celsius temperature goal, which the court noted is, they affirmed it as a survival threshold. It's not just a political aspiration. Regarding the nationally determined contributions, the court set forth the obligation that they must be progressive and collectively sufficient to achieve that 1.5 degrees Celsius target, and that states must pursue concrete measures in meeting to try to meet their NDCs. The court also set forth the obligation under the Paris Agreement that adaptation and cooperation obligations have to be implemented in good faith including through, again, technology transfer and finance. And then under Article 8 of the Paris Agreement, that encourages parties to the agreement to adopt a cooperative and facilitative approach with respect to loss and damage associated with the adverse effects of climate change, including recourse to the mechanism established under that provision. So although the court notes that Article 8 doesn't provide a basis for liability or compensation, it did determine that any breach of obligations related to loss and damage from climate change must be assessed under the established customary international law rules on state responsibility. So now just kind of quickly moving to that customary international law arena. As mentioned, the court confirmed that obligations to protect the climate system arise outside of just treaty law. They also arise through customary international law and general principles. So the court set forth the obligation, the duty to prevent significant harm, under which states must prevent significant transboundary environmental harm by acting with due diligence. And also a failure to prevent such harm would constitute an internationally wrongful act in the court's view. There's also a duty to cooperate. So coexisting obligations inform each other, and the court considers that the customary duty to cooperate for the protection of the environment reinforces the treaty-based cooperation obligations, which are established under the Paris Agreement. And then there's also a human rights dimension. So states have obligations under international human rights law to ensure the effective enjoyment of human rights through the protection of the climate system. Now, just quickly turning to question B regarding the legal consequences. If the court, well, so I'll just start by saying that under the obligations set out in question A, if a state breaches those obligations, then such a breach would constitute an internationally wrongful act entailing the responsibility of that state. And so the legal consequences that result from committing an internationally wrongful act, a breach of one of those obligations, could include the cessation, assurances, or guarantees of non-repetition, and full reparation. So cessation would be stopping the wrongful act or omission if it's continuing to be ongoing. So for example, it could be fossil fuel extraction. Assurances or guarantees of non-repetition would be committing to not resume such harmful activities once they've been found to be a breach of the obligation. And then full reparation could include restitution, compensation, and satisfaction where a causal link between the wrongful act and the injury exists. And in case we have time to kind of go back during the Q&A, we could perhaps talk a bit more about the court's findings on attribution and causation. I'll just quickly say that the court did find in relation to private actors, so for instance, a company perhaps, that a state could be held responsible if it has failed to exercise due diligence by not taking the necessary regulatory and legislative measures to limit the quantity of emissions caused by a private actor within its jurisdiction. So if a company is emitting too much and a state hasn't done anything to stop it, and that leads to loss and damage, then they could potentially be held liable for that. So if just kind of in summary, then the court's reaffirmation that the failure to adopt the appropriate mitigation or adaptation measures could amount to an internationally wrongful act, which then goes on to provide the legal foundation for the claims related to loss and damage potentially. And then, as I mentioned, we'll go on to, if there's time in the Q&A, to talk a little bit more about some contentions regarding the causation and attribution. But I will also just take a moment to briefly go through the kind of Loss and Damage Youth Coalition's aims to advocate for at this COP, which would be to make loss and damage a standalone agenda item under UNFCCC as the third pillar of climate action, alongside mitigation and adaptation, to establish a report to guide finance mechanisms and to mobilize new, additional, accessible, and grant-based funding for developing countries and frontline communities, to ensure all developing countries and communities can access funds without heavy administrative or debt burdens, and then to provide a clear definition of climate finance, to provide inclusive and community-based climate action, to the reform of international financial architecture, to kind of have countries submit their updated NDCs with economy-wide emission reduction targets and quantified actions for loss and damage, to have a just and equitable transition, transparent reporting, and also to ensure that $300 billion is directly accessible for developing countries, to prioritize public finance, and to clarify targets for adaptation and loss and damage in the roadmap to the $1.3 trillion. And so with that, I think I'm over time. You heard my alarm go off there. So I'm going to turn over now to Liliana with Global Choices. Thanks so much.
Thank you very much. Wonderful points.
Hello, can everyone hear me?
Liliana? Yes, please.
Yes, thank you so much. Can someone share the slides? Thank you.
Moderators, do you have the slides?
We don't have the slides.
And now it's being.
It is in the same Google Drive.
Oh, yeah, I'm just opening. Just give me 1 minute.
Okay, thank you. Well, in the meantime, I do not want to lose any more time, so I just wanted to quickly introduce myself and also the organization as we deal with this technical difficulty. So, good afternoon, everyone. My name is Liliana Fan, and I am an Arctic Angel with Global Choices, and we protect the cryosphere and the Arctic. And I'm also a space and planetary law scholar at New York University. And I would also like to briefly introduce our organization. Yes, thank you so much for the slides. Slide 2, please. So the next page. If you could just scroll down, I think it would. Yeah, thank you so much. So Global Choices, we are an organization that calls for collaborative and collective governance for the common good. And we also call for climate security, peaceful and a just planet, and for generations to come. And as for Arctic Angels, we are a subsidiary, and we are currently a network of 74 young women being climate activists who advocate for the ice crisis, now representing over 40 countries. And Global Choices, we're calling for a 10-year moratorium on exploitative activities in Central Arctic Ocean and on area beyond national jurisdiction, BBNJ. So we like to emphasize that this would be an area on the high seas and that we will not be touching on national jurisdictions. Next slide, please. Yeah, thank you so much. So why are we calling for this 10-year moratorium? So just a quick explanation as to why the cryosphere is important. The ice in the Arctic and in the Antarctic has a global climate regulatory function through reflecting sunlight, and this is called the albedo effect. And as you could imagine, such melting of the cryosphere has a huge impact on the Arctic indigenous communities and the wildlife. And actually, this has a beyond local impact. Apart from the Arctic, because the Central Arctic Ocean ice actually regulates wind and atmospheric currents. Therefore, it is important to note that it also has an effect that is beyond the Arctic and also affects SIDS, for example, and the rest of the global south. And a quick explanation about the jet stream, as you could see on the second bullet point, there's a thick band of air maintained in the Arctic, but it has a very high temperature difference from the mid-latitude air. So the cold air from the Arctic is starting to escape, and it is causing extreme cold to other areas, and more extreme weather events will happen in other areas through oceanic and atmospheric currents that are affecting other regions. So it is very important to address this issue because it is a global problem and it will definitely affect other regions for years to come. So with our 10-year moratorium, it is different from the other organizations because for the other organizations, they have also promoted protection of the Arctic. However, we are promoting a 10-year moratorium specifically because it is more practical given the current political climate. And we want states to kind of sign themselves up for the stop of oil and gas exploration, deep sea mining, transpolar shipping, and nuclear waste dumping and CO2 emissions, amongst others. And this is a precautionary principle with pause, which is in alignment with the ICJ's recent advisory opinion on climate change. Next slide, please. And due to time constraints, I will be speaking less on this part about Indian monsoons. So the idea of this is basically, as I've said, the melting of the Arctic ice actually affects the Indian monsoon as well. And this is important because 50% of the agriculture in India is actually based on rain. So with such effect on the Indian monsoon, will lead to food insecurity to 1.4 billion people. And this would also lead to a displacement risk. Next slide, please. Yeah, so there is definitely a link between climate migration and sea level rise due to the cryosphere melting. And with the ice melting, this will cause a sea level rise and extreme weather events. And apart from affecting indigenous peoples in the Arctic who might need to kind of relocate, many other countries will also be affected, like Nigeria, India, SIDS, and other countries in the global south. This could cause a displacement internally and externally as well. So my presentation's focus will be on non-refoulement. So according to Article 33 of the Refugee Convention, it actually excludes people displaced due to climate change. And because the legal definition of refugees in the convention actually says it will be owing to the well-founded fear of being prosecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion. So given this definition is actually quite restrictive in the sense that people who are displaced due to the effects of climate change will not be included in this definition. So therefore, we could see that the framework that established non-refoulement for climate change specifically is through this case called Tediota and New Zealand. And a summary of the specs of the case would be Tediota is actually a Kiribati national who attempted to apply for refugee status in New Zealand, and on the basis that the effects of climate change posed a risk to his right of life under Article 6 of the ICCPR. And so the main things that he has faced was violent disputes, lack of access to safe drinking water, deprivation of his means of subsistence due to salinization, as well as overpopulation and intense flooding. However, despite this case, the HRC has actually decided that there's no breach of Article 6 by New Zealand. And so what are the limitations of the current framework? First of all, there's a very high threshold for the severity of life-threatening conditions. And for example, in terms of water supply, Tediotic's family actually suffered a lot of health implications upon returning to Kiribati. In particular, one of his children suffered from a serious case of blood poisoning due to contaminated drinking water. However, the committee still found that even though 60% of the residents relied on rationed water supplies, they concluded that Tediotic has failed to demonstrate that fresh water was actually inaccessible, insufficient, or unsafe. And secondly, on the lack of means of subsistence, Tediotica actually relies on subsistence farming and had to relocate after returning. However, despite this relocation, he still faced the same issue of salinization, which affects his ability to grow crops. However, the HRC decision dismisses his claim on the grounds that it is not impossible for them to grow crops in Kiribati as a whole, and therefore he failed to provide sufficient information for, about this problem. And secondly, on the real risk test, there's a report that has shown that Kiribati is sinking in 15 years. However, the committee acknowledged that the Kiribati government was taking steps to address effects of climate change, but without assessing whether the government has taken sufficient measures, stating that it was not in a position to evaluate its sufficiency. However, I believe this is problematic because it turns a blind eye as to whether there's a real risk. The committee's reliance on the existence of mitigation efforts rather than actual effectiveness leaves excessive rooms for states to avoid responsibility without ensuring their actions are meaningfully addressed. And thirdly, on the most significant shortcomings of the Tediotic decision is actually the fail to account for cumulative effects of the present conditions. Rather than addressing the combined effects of climate change and multiple environmental and humanitarian factors, the HRC evaluated each issue in isolation, which is not reflective of the current situation with climate change. And on foreseeability and eminence, another limitation is that it has been it is largely focused on the failure to meet other conditions rather than developing a framework for assessing how foreseeable or imminent climate-related harm must be. And such lack of analysis is likely due to the inherent difficulty of applying these concepts. However, it is still important to note that foreseeability and eminence, which is used in the regular refugee framework, is not suitable for refugee claims concerning climate displacement. And lastly, on personal risk and collective rights, citing General Comment 36, the HRC has repeatedly stated that the risk to the right of life must be personal rather than the general conditions of the state, except in extreme circumstances. However, this approach is very problematic, especially in the context of climate change, which affects the entire community instead of just isolated individuals. Next slide, please. Yes, given the time constraints, I'll just quickly go through what I believe the solutions could be for the current circumstances. So we need a whole systems thinking and interconnected approach in climate change, human rights, and migration law. And we need to take account to collective rights and indigenous perspectives. And we need to, most importantly, lower the threshold for severity of life-threatening conditions, as I've explained, and also have a cumulative assessment in climate change. So we need a more perspectives on the protection of persons in the climate change regime in general. And secondly, on regional initiatives, given that the prospect of changing the Refugee Convention or having an international agreement on migration currently with the political circumstances is difficult, regional initiatives could be looked into instead. And finally, we need to promote the 10-year moratorium to protect the cryosphere so that we can lessen the possibility of people needing to migrate. Thank you so much. And I'll now pass the floor to my colleague from Global Choices, who will now talk about loss and damage in relation to climate displacement. Thank you.
Thank you very much.
So, hi. After that, I'm the one that's going to present now. I just ask for 1 second to try to share the screen on the presentation. But I just would love to point out that's going to be such a challenge because everyone is having such great presentations that try to not repeat what all my colleagues have already said. Is going to be very, very hard. So I will try my best. Let me know if it has like any problems with my audio, please. Okay, so what I thought about doing at this presentation to not again repeat what all my colleagues are presenting so completely is how we can reach people in a context of climate mobility with the loss and damage framework. As we've seen, we have the framework, we have the issues of mobility, and I thought about trying to merge what we know about loss and damages and what we know about displacement. So just a brief overview. When we talk about loss and damages, we can talk about like 2 different aspects. We can be talking about the institute that we have, the mechanism, but we can also be talking about what loss and damage means and the sense of everything that's lost, everything that is accounted for when we talk about the climate change effect. So we are talking about material impacts, of course, but we are also talking about spiritual things, memories, cultures that are being left behind, and how we calculate the amount of money that those things actually cost. How much does the memory of a loved one that's being left behind place of their rest? How can we replace that? How we replace the connection that people have to the land if they are indigenous peoples and their culture is being left behind. But with this in mind, I thought, well, let's talk about numbers that are measurable. So when you're talking about the materials that are being considered in this aspect of loss and damage, what we know that according to the World Bank, more than 200 million people could be forced to move within their own country in the next years. We know that according to IDMC, at the end of 2023, 6.6 million people were living in displacement. So they already lost their houses, they lost the place they live, they lost the cultural connections. And we know that some regions are more affected than others. We know that the small islands, we know that the Caribbean, they've been heavily affected. We know that the Pacific region is one of the most prone to disasters. And this has a lot of things to do with not having resilient infrastructure because of years of exploitation, years of colonization. So yeah, they fit into the logic of loss and damage. So they are not the ones that contributed more, they are the ones suffering more. But as our presenter said, like, okay, but how we can, what's the state's responsibility? Like not only the international one. And of course, the state does have a lot of responsibility because in the end, the states the one that are trying to deal with people that are displaced within their own communities. But then we need to think, how much money is spent on emergency solutions when a disaster occurs? What's the economic loss that is being put upon when a city is overflooded and then everything gets trashed and needs to be cleaned, rebuilt, shelters need to be promptly implemented. I'm from Brazil. We are seeing this in the south of Brazil very often. Like the cities where some houses stay there, but they are not livable anymore. So how much money do we need to rebuild this? And what to do when the house is lost to erosion? How much money we need to implement to move someone to somewhere else that's safe, but doesn't have infrastructure to receive them. So we don't have health policies, we don't have jobs for these people, we don't have a housing system. So what I'm trying to tell here is like the whole circle of disasters that we need to think about when you talk about how much money is spent in this context. And again, who is disproportionately affected is people with low-income countries where they have low GDP, and in the sense, countries that are generally not even responsible for the large amount of emissions are the ones that need to deal with the climate crisis. And again, we have a huge amount of money that we know that's being already spent in disasters in Asia, for example, but it does not consider what is like indirect aspect. It does not consider what's not economic. The loss of the spiritual abundance and also the amount that's being implemented for the host community to deal with people that were left in this scenario of disasters. And thus, the mobility, what I'm trying to tell here, is that it also poses as a form of, just a second, is also
Hi, sorry, I had an audio issue. So the mobility is also a form and a consequence of loss and damage. It is also severely affected by the impacts of climate change, and also can be a factor that contributes to the loss and damage itself, as communities leave their lands and suffer economic and non-economic losses. And what can be done? So action that supports to avert, minimize, and redress loss and damage must be informed by data on displacement. If you have policies, we can have less loss. And if we know what is the people being affected, they can actually be, we have a proper policy to deal with that. Gente, só minutinho, por favor. And for this, we need also to consider disaggregated data. So who are the people who are displaced, what are their needs, and what kind of vulnerabilities we are considering. And also we need to consider the expenses that must be considered in the ecosystem surrounding the loss, housing, healthcare, and protections. Just finalizing it. So as my colleague already shared, we have already been discussing this in many COPs. We have not, this is not new, and this is not like brand new information, but we are not actually reaching the people that need it most, because, well, how does the mechanism functions? It's like a loan, and it needs a lot of informed policies and data so we can have the money from loss and damage funds. And that's not so easy to get. So people that are in the front lines, people that are the most affected communities, are not the ones that are actually getting the money. They are not the ones that are actually reaching that. So we need a specific policy. We need to listen to those groups, and we need to have encompassed collective quantified goals. So like we need to mobilize loss and damage and understand the financial and needs of each person. So what should be done is understanding the modality. We need to make funds easier to be accessible by people that are in the front lines, so people don't need to move. So move doesn't become like a loss in itself, but a choice. And then we can have like countries working on it, but we also can have people that want to staying without that amount of loss. And so the main thing that I would like to say is that we need to accept the knowledge that differs from the one traditional being heard, and we need to demand that measures but be taken to create safe locations, minimizing the chance of environmental climate displacement, and again, listen to people that are being affected because they know how to do with their lands. They can propose solutions. So that's what we should be thinking about. Thank you for your time. And sorry for the small issue that I had. Yeah, thank you so much.
Thank you, Marilia. Thank you very much. Moderators, I hope we have 2 more speakers. Am I audible?
Yes, sir.
Yeah, we have 2 more speakers. I believe Advocate Cindy Rojas is there.
They are discussants.
They're discussants.
Discussants. Okay.
So now we can go to question and answer sessions.
Perfect. Yes. We have 20 minutes, I think, now. We need to have about 15 minutes of Q&A.
Yes, we can do 15 minutes.
Yeah, thank you so much, speakers that have shared their valuable thoughts, and it was really great to hear everyone's presentation. It was well informed, and I hope that everyone can hear me clearly.
Yes.
Yeah, thank you so much. So I'm going to start with the one question that we got in a chat box from a Camilla, that from the UK, can international law realistically move from an anthropogenic to the ecocentric model of justice, or will human interests always dominate? So the question is from a Camilo, and anyone can answer about the question.
I think this question connected with my presentation, like anthropocentric view, ecocentric view. So in this, like, if we take a purist approach of ecocentric perspective, like ecocide, then at the end, all law policy are framed by the human beings. So there is a necessity of a minimum anthropocentrism even in the ecocentric approach. So it should be ecocentric approach, inclusive of the human participation. So participation, we talk about the meaningful participation, where community at the grassroots, their views should be taken into consideration while framing the policy, because they are the people close to the nature, close to ecosystem. They are the first to get affected. And so any law and policies should be framed by taking into account their views, their cultural life, their spiritual life, their daily work, their livelihood. So when we talk about the loss and damage also, it should not only be economic, but it should have other considerations like spiritual consideration, the consideration of the livelihood, psychological consideration, coherency of the social environment. So these perspectives are inevitable to stay in the ecocentric approach. So there can be a balance of ecocentric approach taking account the participation of a community. So yes. I think this can have a good balance.
Yes. Thank you, Harendra. Yeah. Cindy, you would like to come in now?
Yes, thank you very much. Can you listen to me correctly? Hello?
Yes.
Yes. Thank you. Yes, I have the following question. In your opinion, what are the best ways to improve multinational corporations' liability for their wrongdoing in today's landscape of impunity?
The question is addressed to?
To anyone who can speak about the topic.
Right.
So I can take that one from Cindy.
Please go ahead.
Yes, so we have spoken about the widespread impunity of environmental crimes, and this is mainly because there is an international treaty that is binding and that is actually managing the activities of the multinational corporations. So that, of course, would be the best option, right? However, we know that there are many economic interests that give us the situation that we have now, where we have soft law mechanisms that actually are putting the victims in a space where they don't have redress. However, there are other solutions as well, that is to develop judicial mechanisms to enable home state responsibility based on the notions of effective control and the duty of care. This means the possibility to assert jurisdiction from the courts where these multinational corporations are headquartered, and this is already happening in the common law system in the US and in the UK. So that could be something that in the future we will see a development. And yes, I would say these two solutions could bring more accountability from the wrongdoings of the multinational corporations.
Thank you. Next question, please.
There's one from Stacy Alvarez, who's based in Barbados. I noticed the distinction between economic and non-economic loss and damage as categories. Do any of the panelists see the possibility of using intangible as a category to include the psychological impacts of extreme weather effects caused by climate change? Also, we must explore appropriate tools to quantify these losses.
I think I can just give like a small topic about this, like a small. But I think that the psychological part is being considered when you say that's like not countable. The only issue is that how we measure that, and that's such a difficult and fine line. That's actually going to be super hard to measure. But yes, it should be encompassed. I just don't know how we can implement it. And then the people that have talked about like how to judicialize this can provide some more info and like maybe ideas on that. Thank you very much.
Thank you.
I might just jump in and tag off of that to just echo what you've said, as well as kind of under the ICJ Advisory Opinion, there was causation, as it was discussed, was kind of this, that there only needs to be really a sufficiently direct and certain causal nexus between an alleged wrongful action or omission and the alleged damage. So there is some flexibility in that. But when the court established kind of the elements of causation, they gave the first element, whether a given climatic event or trend can be attributed to man-made anthropogenic climate change. And the second element, to what extent damage caused by climate change can be attributed to a particular state or to a group of states. And so when they gave flexibility within establishing causation, they gave it mostly to that first element. You can use, for instance, the IPCC they gave as an example as providing the necessary science to show that a certain climate event was caused by anthropogenic climate change, that they said there's an abundance of data to this end. But the second, about what damage has been caused, they did mention that has to be established very specifically on a case-by-case basis by the parties that are asserting that they have been adversely affected by climate change. So that state would need to be able to somehow quantify the damage that they've experienced. If it is, their population has experienced a psychological impact, I think it would just come down to how they manage to quantify that in the court's view. So,
thank you, Mawe. Next question, please.
There's a question for Marilia from Timothy, who's in Nigeria. Your statement, if we have policies, we can have less losses. How correct is this? Do you mean we don't have enough policies already to reduce losses?
That's a great question. What I say is that when we talk about loss and damages, we always see like a top to bottom solution. So we think about what the state thinks that should be happen, what should be done, but we are not listening to the people that are in front lines that are being most severely affected. So we need to understand what's going on, and then we have like a more policy focus on the individuals, on the basis, from the grassroots movement maybe, or from the people that are in the front lines. When we have more policy-informed strategies, we can understand and build resilience that makes sense. So again, I'm from Brazil, but I studied a lot of the South America region, and rarely people that are like in places from erosion are being heard, and their solutions from what they need is being protected. What means that we have like broader solutions, broader policies, but that doesn't reach the actual people on the ground. And so the policy exists, but it doesn't make sense, and then we don't actually prevent the losses. So this is maybe not more policies, but policies that make sense, policies that listen to people on the front lines, policies that understand the different degrees of vulnerabilities and different places that people are being affected. So I think I made myself a little bit clearer, but thank you so much for the question.
Thank you. Any other question is there now?
Yes, one from Fatima Nisar. Adaptation must be top priority in those countries that are high in vulnerability due to erratic rainfall, floods, and droughts. What are the best practices in climate resilience law and policy that can be immediately adopted to protect critical sectors like agriculture, water and infrastructure, and empower local communities to cope with the inevitable impacts of climate change, specifically addressing issues of loss and damage?
Will you take up? Marilia, can you take up this question? Yeah.
Just a second. I would like to ask to repeat the question so I can frame it better.
Sure.
Just while I solve some issues here.
Okay, I'm gonna read it again.
Sorry to step in.
Did
Perhaps I
anyone
could.
wanna?
Step in,
sure.
but this question is very long. You can answer personally over email. Now we have to go to the chairs. We just left last 7 minutes.
How much time we have now?
Conclude. We have last 7 to 8 minutes.
7 to 8 minutes. So before that, I'd like to just ask, the discuss answer. Would you like to, share any of your views now? I see Professor Camilio Cuba is here.
Yeah, he's here.
Would you like to share your views?
Yeah,
2 minutes or so.
Sure. Just to thanks the speakers and everyone that participated. I think that the possibility to reimagine new legal frameworks, especially in the environmental field, is quite urgent. But the fact to have such professionals and giving lawyers or legal advisors that are willing to give a space to these new narratives is valid enough. Somehow I'm trying to do the same where I'm located with the experiences I have. So yeah, I just wanted to highlight that and the necessity to explore these new narratives and to give them the legitimate force in order to be taken, considered seriously by courts or tribunals or even executive branches from governments all around the world. I think that's highly valuable. And yeah, my admiration, and I'm really happy to be involved with these types of reflections. So congratulations to all, and let's see what are the following days at the COP. Hopefully we will have solutions with hope, and something that we can all be happy with. So yeah.
Thank you. Cindy has already spoken. Cindy, you would like to say anything now, briefly?
Yes,
Before concluding.
yes, totally agree with Camilo actually on it. And I think that is wonderful that we have this space to discuss these new topics that are like urgent for us and for the humanity in general. So yes, same. We are looking forward to see what are the new resolutions after COP, and hopefully we can have a positive outcome. Gather in a new opportunity to discuss and reflect about it.
Very good. Thank you. So crisp. Thank you so much for all the speakers and the discussants for bringing out very important points here. I think we cannot go by the speakers to identify the takeaways. So if I can identify the major takeaways here, we need to push the systems, international the systems, to recognize ecocide as one of the crimes, the fifth crimes in the Rome Statute. That is one of the major points which came out here. I really appreciate the arguments and the support for that purpose. And we need to establish greater accountability. Here, I would like to insist here that not only the corporate accountability, the state accountability should also be considered in this point. And, Harindra has very rightly pointed out that we need to go for an innovative framework that will recognize the transformative reparations and ecological justice. So this is another point. And we need to take seriously the loss and damage. And the loss and damage fund has to become operational, and we need to really recognize how it will be benefiting the people who are affected. And another important point which came out here is that the migration, the displacement, and the climate-induced refugees. So we need to create mechanisms to address these issues. So these are the major takeaways which has come here. Now, I would like to invite Dr. Ramesh to share his views to conclude also.
Thank you, Professor Pushpa Kumar. And I really appreciate and thanks all the participants for their insightful and engaging session, including question and answer. I would like to highlight few points from each speakers, starting from Advocate Rickwell and Advocate Beneval, discuss the role of international law and how it often sits at the margin of people's lived experiences, using examples of crimes, victims, and recent positive developments from International Court of Justice and the Inter-American Court of Human Rights. Advocate Beneval also highlighted ecological justice and community-driven accountability and lesson from Niger Delta and gas tragedy in India. That reminds us that how we need to bring such a transformative approaches that centers people instead of states and corporate alone. Advocate Muhani clarified the loss and damage framework and state responsibilities under Article 8 of Paris Agreement, and Advocate Mary elaborated on ICJ Advisory Opinion requested by the United Nations General Assembly, focusing on obligations related to climate change.
Just 1 second. Yeah, I think we were warned that we have only 1 more minute, if you can.
Sure, just finishing it up. And Advocate Liliana connected the loss and damage with climate-induced migrations and drawing in examples from ice crisis and monsoon disruptions. And Advocate Marilena addresses how losses and damage mechanism can better support people experiencing climate mobility. So with that, I would like to thank all the participants and all the participants and respected speaker of this session, and people, specifically the people who ask questions here and bring this positive takeaway and messages across the globe. So I really appreciate everyone, and thank you everyone. Appreciate.